Again, continuing with our series of Supreme Court case law in the last 1 year. Today's topic being whether project office, which is established for communication purposes, whether that constitutes a P, that is permanent establishment. The case is referring of Samsung Heavy Industries Company Limited. So let's get started, friends. Before start, would like to acknowledge the efforts of Deepika and Gracelyn for preparing this PPT. The legends used pretty similar to what we have seen before. ONGC, which stands for Oil and Natural Gas Corporation. The schema for the evening, background and facts of the case, the history of the case, what all happened before Supreme Court till High Court level, what all things happened, what were the contentions, principles and precedents governing the rule of P, SC's verdict, conclusions and key learnings. So backgrounds and facts of the case. Generally, the concept of P is used in DTAAs to establish a country's tax jurisdiction over a foreign company's business activities. So foreign non-resident, if there is income from business, apart from the residence country, the profit would be taxed in source country only when there is a P of that non-resident country in India. In that country. So in case of business income, taxability will occur only when there is a permanent establishment of that non-resident in the source country. So coming to the facts of the case for our case law, in 2006, ONGC ordered a turnkey contract to Samsung, that is the Assessee, which is a South Korean company engaged in business of heavy engineering. Assessee carried out coordination and communication activities in India, design and engineering activities in Malaysia, fabrication inquiry in Korea and Malaysia. On arrival of goods from Malaysia to India, installation and commissioning activities are carried out in India at Mumbai offshore. ONGC asked the Assessee to open a project office in Mumbai for the purpose of coordination and communication between the parties to the contract. On an admitted position, Assessee had an installation P in India. So Assessee has confirmed that it has an installation P in India and regularly it is filing the return of income. But for that P, there is a loss, there is no profit. So every year for that particular installation P, the Assessee is filing a loss return. So Assessee has no issues with installation P being in India. Now here the question is, or the contention of department was whether the project office which is being created or which was asked by ONGC to the Assessee for the purpose of coordination and communication, whether that project office would be regarded as a P in India. So as I said, friends, the dispute revolves around the following one question, that whether the consideration received by Assessee, which is again a foreign, against offshore supplies made by it from outside India is taxable in India on account of P, project office P being in India. And if yes, how much of the income can be attributed? So we'll see it from the assessing officer level, what were the various contentions at different level. AO's draft order. So AO passed an order saying that the project was a single indivisible turnkey project, whereby ONGC was to take over the project completed only in India. Secondly, what the order said is the profits arising from the successful commissioning of the project would also arise in India. The work relating to fabrication and procurement of material was part of the contract for execution of work assigned by ONGC. The work was wholly executed by the PE of the Assessee in India, and accordingly, assessing officer attributed 25% of the revenue which was earned outside India by Samsung as attributable for operations in India. Against this order, there was a appeal filed with DRP, but again DRP upheld the order passed by assessing officer. So again DRP took a stand that yes, there is a project office P, and there has to be a profit attribution. Again agreed by AO's final order upon directions of the DRP. The taxpayer filed an appeal with ITAT. So what was the ITAT's contention? ITAT referred to the board resolution of the Assessee for setting up the project office in Mumbai pursuant to ONGC's request. The board resolution indicated that the PO was set up for coordination and execution of the project. So board resolution had categorically stated that the project office which is being created, that would be for the purpose of coordination and execution of the project, and nothing else. ITAT held that this constituted a PE of the Assessee as it was integral to the performance of the contract between it and ONGC. Accordingly, the ITAT confirmed the decision of the AO and the DRP. So what ITAT said is, as the assessee, that is a non-resident, is involved in coordination and execution of the project, this activity forms an integral part of the entire contract, and hence it concluded that there is a PE of non-resident, PE of Samsung in India. As usual, the ITAT confirmed the decision of AO and DRP. Agreed by the ITAT's order, the appeal was filed by the Assessee with the High Court. What High Court, which was again an Uttarakhand High Court, what High Court ruled? If an enterprise, that is as per India Korea DTW, if an enterprise does not have a tax identity in India in the form of a PA, it has no obligation to either submit any tax return or pay any tax in India. Neither the AO nor the ITAT had recorded any evidence to justify that the project office of the taxpayer is a PA in India. So there were no efforts. So what High Court observed, that there were no efforts made by the assessing officer as well as the ITAT to confirm that the project office of the taxpayer is a PE in India. It just referred, there was no genuine efforts made to confirm whether that project office constitutes PE or not. So the High Court ruling came in favor of Assessee, stating that there is no PE in India and accordingly no profit attribution. Agreed by the High Court's order, the revenue challenged the High Court order in Supreme Court. So what were the various contentions of the party, that is Assessee as well as the department? Assessee contentions was, there were 5 points. One, that PO was acting merely as a communication channel. So there are no major activity or predominant or core activities being done. It is only acting as a communication channel between all the parties which are relating to the contract. So the activities of being a communication channel, that is preparatory and auxiliary in nature. The PO, that is again the project office, considered of only 2 employees, neither of whom had any technical qualification whatsoever. So there were 2 employees in project office in Mumbai. Neither of them had any technical qualification to understand the project, how it works, the functioning entirely. None of them had that technical qualification. The accounts that were produced would show that PO had not incurred any expenditure on execution of the project. So if someone was to see the execution part of the project, none of the expenditure were incurred by the project office which was there in Mumbai. Lastly, what it said is like the burden of establishing that a foreign assessee has a pay in India is always with the tax authorities. So that would be the jurisdiction of the tax authority to confirm that a particular non-resident or a foreign company is having a pay in India. So these were the contentions of assessee. What were the revenue contention? As said by assessing officer in the draft order as well, the project was a single indivisible turnkey project which could not be split up, whereby ONGC was to take over a project that is completed only in India. So it was a single indivisible project. Only when the last leg of that project is completed in India, the ONGC will take over that project completely. So that being the case, department said that profit arising from the successful commissioning of the project would also arise only in India. The assessee had not contested the existence of PO in India, but it had only contested the project office was merely for preparatory and auxiliary activities. Here again, what department said is like assessee is not denying that a PO exists, not denying the existence of PO in India, but only contesting that project offices used for preparatory and auxiliary activities. However, PO has a sense of permanence attributed to it. If it was only for the purpose of preparatory and auxiliary activities, they could have established a liaison office. So what was a different angle taken by the department? If the activities were not predominant activities or not that core activities, and those activities reflected the preparatory and auxiliary nature, then assessee should have opened a liaison office instead of a PO office. So these were the various contentions of revenue. Now We have seen what happened at the lower level, that is from AO, ITAT, AO, DRP, ITAT, and High Court. We have seen the contentions of assessee as well as the revenue. Now let us see what are the various principles and precedents governing the rule of permanent establishment, and these judicial precedents were also referred by the Honorable Supreme Court while giving its judgment. Firstly, India Korea DTW, it says permanent establishment means a fixed place of business through which the business of an enterprise is wholly or partly carried on. 54E, that is Article 54E of the same DTW says, P excludes fixed place of business solely for the purposes of advertising, supply of information, scientific research, or any other activity if it has a preparatory and auxiliary character. So if a fixed place of business is being established for these four reasons: advertisement, source, supply of information, scientific research, and preparatory and auxiliary activities, then in such a scenario, fixed place of P, even though there is a fixed place of business, it would not be regarded as P. Now, Supreme Court referred various judicial precedents while giving its ruling. One of the ruling was CIT versus Hyundai Heavy Industries Company Limited, where it was the facts were facts in the case dealt with the turnkey contract entered into between Hyundai Heavy Industries and ONGC, wherein there was a separate agreement to design, manufacture, erection, etc., culminating in another separate agreement relating to installation and commissioning of platform. So what the court held in that case: profits earned by a Korean company on supplies of fabricated platforms cannot be made attributable to its Indian P, as the installation P came into existence only on conclusion of transaction giving rise to the suppliers of fabricated platforms. So even though there was a turnkey contract, there were separate agreements for various activities which were to be performed. The installation P, which which was under the question in that case, emerged only after the contract with ONGC stood concluded. It emerged only after the fabricated platform was delivered in Korea to the agents of ONGC. That being the case, the profit from supply of such fabricated platform cannot be said attributable to the PE. So this was the ruling given in Hyundai Heavy Industries Company Limited, which was referred by Supreme Court. Again, second case law, again a very landmark decision of Morgan Stanley and Co. Here again, one of the group companies of Morgan Stanley, that is Morgan Stanley Advantageous Service (MSCS), which is again entered into an agreement for providing certain support services to the US Morgan Stanley company. MSCS was set up to support the main office by providing IT-enabled services such as back office operations, data processing, and support center. So these were the activities which were being performed. According to the DTW between US and India, these activities would fall within the ambit of, or rather, as we have seen in India, Korea DTW as well, fixed place of business will not be considered as PE if at all it is relating to advertisement, supply of information, scientific research, or activities which are preparatory and auxiliary in nature. Back office operations performed by MSAS were considered to be preparatory and auxiliary in nature by the Supreme Court in Morgan Stanley. And that being the case, there was no PE for the functions being performed by that back office in India. Secondly, activities performed by stewards who were deployed by the US company to work in India as an employees of the Indian company was so employed merely to protect the American company's interest. So even though there was stewards being deployed in Indian company, those were even though on the roles of Indian company, but they were deployed only to protect the American company's interest. There was no other motive for them joining the Indian MSCS company. That being the case, there is no service PE as well, which existed. In one more case law, ADIT was the eFunds IT Solution Inc. It was held that the burden of proving the fact that a foreign company or foreign assessee has a P in India would always rest with the revenue and never with the assessee. Again, one more landmark case law, friends, Ishikawaji Maharima Heavy Industries Limited. Here again, the court discussed the principle of P. The distinction between the existence of a business connection and the income accruing or arising out of such business connection is clear and explicit. P's non-involvement in the transaction excludes it from being a part of the cause of the income itself, and thus there is no business connection. So what was held is, if a P is not involved in any of the business transactions, or is not involved in any of the functions, main business functions, there is no reason to say that it is having a cause of generating income by itself. Thus, it was held that if income arises without any activity of P, then even under DTAA, the taxation liability in respect of overseas would not arise in India. So again, if you see, friends, from all these four case laws, what was referred by Supreme Court is three main things. If P is not involved in any of the core business functions, and it is involved only in preparatory and auxiliary kind of services, then that office or place of business would not be regarded as P in India. The burden, secondly, the burden of P would always be with the department and not the revenue department and not the assessee. So that being the case, and thirdly, it is said that if P is not involved in any of the main business function, we cannot attribute the income of the non-resident in India, as there is no fundamental or a genuine base to such attribution. So these were the three main points which were carved out by the Honorable Supreme Court while giving the verdict. And what was finally the verdict? The condition precedent for applicability of 5(1) of DTAA between India and Korea, and the ascertainment of P is that it should be an establishment through which the business of an enterprise is wholly or partly carried out. Now, the profits of a foreign enterprise are taxable in a country only where the said enterprise carries on its core business through a business permanent establishment. Maintenance of fixed place of business, which is of proprietary and auxiliary character, will never give rise to P in India. So these were the three main things which were observed by the Honorable Supreme Court, seeing the principles of DTAA as well as the judicial precedents. Applying these principles to our case, Supreme Court held that the ITAT order was perverse based on selective reading of documents submitted by the taxpayer foreign company. The resolution which was referred, it said that the PO was, the project office was established to coordinate and execute delivery documents in connection with construction of offshore platform modification of existing facilities of ONGC. So the main purpose of this project office was delivering the documents in connection with construction of offshore platform modification of existing facilities of ONGC. So if you see, friends, here, nowhere in these few words it is mentioned that it would get involved in the main functions or main business activities of the non-resident company. It would only be a kind of a mediator or a communication channel between the parties. Also, favoring the contention of one of the contention of Assessee, the Supreme Court said that whoever were the employees which were deployed in PO and project office, neither of them had a technical qualification to perform any core activity relating to the project. So these two things were stated by the Honorable Supreme Court. Final ruling, again, the activities which are performed by project office in Mumbai, India, that is not a core business activity. That being the case, there is no, it is only preparatory and auxiliary kind of activities which are being done by the project office. That being the case, even though there is a place of operation in India, that place of operation would not be regarded as P. So again, the Supreme Court confirmed the Uttarakhand's High Court judgment in favor of Assessee, and the revenues appeal was dismissed. So the principle related, what are the key learnings, friends? The principle related to carrying out of core business activities of prime importance for establishing fixed place P. There have been companies avoiding tax by claiming that they carry out preparatory and auxiliary activities while actually carrying out core business activity through their licensed project or branch offices. The Honorable Supreme Court in this case has granted a genuine benefit. So now when case went up to the Supreme Court, it read the resolution or the board resolution which was passed to establish such project office. So it read and it confirmed that whatever activities which are being performed by the project office in the gamut of entire project, that is preparatory and auxiliary in nature. It is working only as a mediator. There is no core business functions being performed by the project office. That being the case, there is no P. Accordingly, there is no P, there is no question of profit attribution. So these were some of our thoughts, friends, on the Supreme Court decision for Samsung Heavy Industries relating to P, whether a project office would constitute P or not. Thank you, friends.